Hello, my true crime lovelies. I hope you are well. I hope you are as lovely in life as you are in my mind. Where am I? We got Cranick, Zaddy Cranick, and we have Judge Jackson. I'm sorry, Miss Jackson. Woo! I am for real. Yes, we have. Well, apparently Sarah Boone has found her pen. I think one of our more recent letters, she couldn't get a pen and a paper. She was deprived of basic whatever she needs to be a vexatious litigant. But she's found her pen. We've got quite a few documents to go through, so I'm not going to hold you. I'm going to thank the members. I'm going to roll the intro, and I will catch you on the other side. Thank you for being here. I appreciate you. I would love it if you hit the thumbs up button. No pressure, though. Okay, I'm going to start with the minutes. I want to use it as a roadmap because we've got quite a few documents here. We've got two motions, a tattletale document, and a written financial statement. And so I just want to go through it. We went over this, I think, Friday when the minutes were posted. Now we have more context. So just as a roadmap, the court hereby grants respondents' motion to accept handwritten financial affidavit. So we're going to go over that handwritten affidavit, respondent's motion, and also we read that motion this morning. Sarah called it a motion to understand. The judges called it a motion to accept handwritten financial. So we read that. Judge said, fine, I'll take your handwritten. You didn't need 4 pages to ask me, but okay. And then we go into the motion to appoint a guardian ad litem. That is denied as stated by the court, but we'll read through it. And then likewise, respondent's motion to compel mandatory compliance and enforcement. Court grants in part, admonishes in part. So now I know that is for the pretrial statement, the pretrial conference statement that they were meant to do. And Brian's attorney was like, yeah, it's complicated to get into a prison to see her. And also subtext, she's probably not going to agree anyway. And so they submitted their own and they said they had no objection for her doing so. She didn't do any. So the court grants in part and admonishes counsel for failure to comply with this court order as stated on the record. And then the court gives the respondent 30 days to write out her position on the pretrial statement. So she's not off the hook and she has to do it by herself, which we know is scary for Sarah. She's very codependent and needs people to help her with everything. Respondent's motion to compel petitioner for amended discovery responses, that is denied. That is that lengthy letter or motion where she was like, how much did you sell the house for? What did you do with the proceeds? And then both of them are to submit their parenting plan. So let's start off with her financial statements, which I showed you guys earlier today, that she could have just had one of her minions, flying monkeys, download this document. Instead, she wrote a letter about how sad it was and everybody and their mother that she talked to that told her they couldn't change the rules for her. A family law financial affidavit, short form. I'm going to go through it quickly. Check here if unemployed and explain on a separate sheet your efforts to find employment. I swear she has a job in prison, so I'm not sure why she checked that. Fireworks are going off. Sorry, guys. That's Little Miss Liberty. Reason I'm currently incarcerated. I have a job, but I'm not paid monetarily to receive a paycheck. That sentence makes no sense. Like, how else are you paid if not monetarily? Are you paid in honeymoons? Or maybe she means the money doesn't come to her directly. I'm not sure what that means, but it's a contradiction. Yeah. How are you paid, ma'am? Credits? So section 1, present monthly income. So all these are 0. Gross salary or wages, bonuses, business income from self-employment, yada, yada. Monthly disability, 0, 0, 0, 0. And then unknown monthly alimony actually received from this case, unknown TBD. So it's 0 right now. You know for a fact you're getting nothing. They're not asking you futuristically. what you might be getting in this case. They're asking at the moment that you're writing this. From other cases, 0 in A, because she has no other cases. So I'm just going to scroll so you can see all the zeros. She didn't file taxes, so she got arrested in February of 2020. She should have filed taxes for 2019, and she was ordered by the court to claim the income from her alimony and child support. So, I mean, you can vote in there until you're convicted. Do they not have tax people to help you? Or you can't download like a 1040A, I'm guessing, for her, since she hardly had a job. Or not A, what is it? The 1040 easy. So unknown monthly court-ordered alimony actually paid. And then we have, it says 25A and 25B. So we go to 25A, this case, unknown. It's 0, ma'am. It's at this moment, it's ordered to be 0 until this is resolved. So I don't know. Is that like a slight dry begging? Like,
Judge, you tell me what it is.
Assets and liabilities. So here I found it interesting. She did not mention her 401k. So what happened to it? Because it was listed in 2018. Did she get rid of it? She makes no mention of it, but she does claim. So this is like an old switcheroo. Her car and her personal property. Now her heirlooms and whatnots are worth $10,000, but she has them for both the petitioner and the respondent equally. So is 5,000 of it going to Brian? This confuses me. She knows the car is gone. She sent that note to the judge already. So she's playing a dangerous game here because you're lying. Both of those statements can't be true. The car can't be an asset to you for $8,000 or 4,000 to you, 4,000 to Brian, because that's what you've indicated. But I don't think that's what you've meant. But it can be an asset to both of you and also no longer yours. So she's added that up as total assets. But here, for some reason, even though, again, this is petitioner and respondent, even though she's checked it for him in this box, it doesn't total to 18 for him. It only totals to 18 for her. So if he's got 4,000 here and 5,000 there, shouldn't that be 9,000 for him? Only in Sarah math. And so then also down here as a liability. So now all of it, 18,000, is a liability just to Brian. He doesn't have the car, so it's not a liability. He doesn't have the storage unit, so it's not a liability. So you guys tell me what you think she means, because that one just was like, huh? And then again, contingent assets that you're requesting the judge to award you. So these were already settled in the original marriage settlement. So I'm not sure what, it's already done. It would be like if she added the house to this, right? It's already done. You were awarded the Kia. So asking the judge to award you the Kia again does not make sense. The storage unit was not a part of the original settlement because you had all of your things then. So adding it now does not make sense, right? You can't, but she's still trying to get money from him. She's still like, where's my stuff, right? The other motion that she filed previously was ignored. So then she's going to like back into it, but it's really just ass up. More than anything. That's that average monthly expenses. So she's saying for food for $250. Why, ma'am? You are in the care, custody, and control of Florida, of the Florida Department of Corrections. What are you spending $250 on for food a month? That's too many sugar packets or artificial sugar packets and coffee and honey buns and zuzus and wham whams for me. But okay. She doesn't put medical on here, which I think is interesting because she does have to pay for medical, right? If she goes to see the doctor and she's, what did she say? Pre-diabetic, pre-cancerous, post-cancer. So she doesn't include any of that. And I believe she has a daily housing cost. She doesn't include that. But her child expenses, gifts for holidays, $100, and communication, $200. So does she want Brian to pay for her to talk to her son? Or is she just saying why? Because she's not, she's billed $200 potentially. Hopefully that's what she's saying. She's not. It's not of her own money. Like other people are donating money to her. Not really a donation because you can't count it on your taxes. Like she's not a 501c3. I'm confused by that, but she's tallying up, I need $100, but this, I believe, is that child support pot that she wanted, right? When she finally came back, when her flying monkeys realized how bad it sounded and were like, well, let's like soften it a bit. So you'll still ask for child support, but you'll designate that it's meant for the child. You just will direct it. But according to Lana, she also meant money for the child to buy her thing. So that pot of money, let's just say it's like $500 or whatever, 200 of it would be for her son to buy her gifts, right? Which is a little cray cray. I mean, he's 14. He could have a paper route. If he really wanted to get you a gift, ma'am, why does his dad have to pay for it? So clothing, $50. I don't know what that means. The panties were $350 in jail. Is that what she's getting? And this is monthly. Like, is she paying for laundry? What? Okay. Medical dental. Okay, so she did have medical dental here. Hygiene, $50. Writing items, $20. Nobody is willingly going to fund your writing items, ma'am. And you're writing this. So how did you pay for these? So $70. It wasn't, I don't know, she wasn't getting a lot of hygiene stuff when she was in jail. The soap that she bought, she returned. I think she had some shampoo. Like, how she doesn't have that much hair. How much shampoo is she going through a month? Shampoo, deodorant, soap. Surely she's in menopause. She's looking like she's lacking estrogen. Anyway, payment to creditors. Your creditor is the Department of Corrections.
I think that's your caretaker, ma'am. Don't think they're your creditor.
So she's saying clothing is charged quarterly. So is that a quarterly charge? What would that be? No, if it's quarterly and it's $50 per quarter, that'd be $200 for the year. $50 if that is for the whole year. I don't know. She's not explaining how she did it. My brain is hurting trying to figure it out. I'm usually quick with the math. Okay, child support guidelines worksheet is or will be filed in this case. This case involves the establishment or modification of child support facts. Certify that a copy of this document was, check all email, and then from the court's e-portal system. So she's filing it publicly and then expecting that that will go out to his attorney, and then under penalty of perjury. So that is the foolishness that is her financial statement, which I feel like is all lies. We're going to go on to her guardian ad litem request, which was denied. This is 4 pages. We'll go through it quickly. This was sent on May 15th. Now, she sent this on May 15th, which is before the May 19th of her motion to understand, even though her financial document was due on the 20th. Let me just peek back at this because when did this other one go? Excuse me. Oh, she sent this other one, the financial affidavit, also on the 19th as the same day she sent for the understanding. You guys let me know if that makes sense to you. Okay, so this one got to the court on May 30th. She sent it on May 15th. Respondent's motion for court appointment of guardian ad litem to reserve and protect her parental rights, not to protect the best interest of the child. Comes now pro se respondent, Sarah K. Boone, respectfully moves this honorable court for the appointment of a gal pursuant to blah, blah, blah. This is a family law matter involving parental responsibility, time sharing, and other issues affecting the minor child between the respondent and petitioner. Time sharing? Time sharing. Okay. Is the phone call a time sharing? Is the video visit a time sharing? Even if he comes in and you guys are like behind glass, is that time sharing? Because Brian's got to be there. He can't get himself there. And I noticed Brian is not on the visitation list for her at DOC. So does she expect him to sit out in the parking lot in the Florida heat? Anyway, due to the inappropriate allegations and repeated ongoing slander made by the petitioner regarding the surrounding circumstances. So what do you guys think is a slander? Because before, pre-sentencing, pre-conviction, she was saying he was calling her a murderer. But now, in fact, she is a convicted murderer. So what do you guys think the slander is right now as we sit here, June 4th, 2025? Let me know down below. She believes it is vital to her preservation ability of her invaluable parental rights. They don't sound invaluable. It sounds more like that alimony is invaluable to you, but go on. And the protection of their minor child's best interest. Oh, now we get to the child's best interest to be clearly presented in this matter between his mother and self. What? To request necessary appointment. Maybe she means mother and father? Like, why? It's almost like she's saying she's a danger to him. I mean, she is, but is that what she meant to say? So the guardian ad litem will help protect him from her or be a middleman between she and the boy. I don't know. To request necessary appointment of a neutral, professionally trained, independent guardian ad litem, all the extra words. Like, they all should be neutral, the guardian ad litem, or for the child. They all should be professionally trained. Like, there's a whole program. We went through that. In Florida, you can be a gal without being a lawyer. There's a certification process. Independent, they should all be independent. They don't work for the mom, they don't work for the dad. To ensure the proper success of the aforementioned for all parties, primarily and foremost, the minor child. Oh, it's the flowery language for me. Respondent is concerned the child's emotional and mental welfare may be heavily impacted by the legal proceedings of this unequally leveled family case. Unequal because of your own actions, ma'am, not because of the court, not because of Brian, not because of your son, because you chose to put your boyfriend in a suitcase and refused to let him out. If you're going to put the unequally in, put that and stop looking for the pity. No one feels sorry for you that you killed your boyfriend. And a guardian ad litem will provide an objective third-party assessment of the child's situation. I mean, if it's unequal to anybody, it's to George Torres. That was unequal. He didn't stand a chance. You made sure of it. Aid in the instability of his understanding of freedom to be himself, answer his questions. Why is his understanding of freedom to be himself unstable? Where's the instability? Aid in the instability. That, I think, would be the last thing you would want, is someone to aid in him being not stable. Provide a voice in his request to be in his mother's life. Does he have those requests? Leading, objection, facts not in evidence, to unburden himself for clarity in his relationship with both parents futuristically, in the place where it looks like the future. A guardian ad litem is empowered under Florida law, blah, blah, blah. All positive, healthy future arrangements that are in the child's best interest, including relational preservation with the parents. While the gal may consider the wishes of the minor child when appropriate, their primary duty is to assess and report what is in the child's overall best. Do you think the judge doesn't know this, Sarah? Do you think the judge is confused about why a gal exists? Who's paying for the gal, Sarah? Is that in one of these? The respondent believes this appointment will be extremely beneficial, fair, and just for the court and all parties involved. Does the court need justice? The respondent graciously... Girl, you need to look that up in the dictionary, because this so far has been anything but gracious. This has been guilt-ridden thus far. But we're only on page 2. Is it too soon? Too soon for me to judge? Okay. Respondent graciously requests that the court determine if a pro bono or low-cost guardian ad litem may be appointed. But you said you don't have any money on the financial affidavit, so even if it's low cost, and why would they work pro bono? Is for shits and giggles? Is there a requirement? Somebody let me know. Do the guardian ad litems normally work X amount of pro bono hours to get their or retain their certification based on the known and unconcluded financial circumstances? Oh my God, the digs of the respondent. Unconcluded circumstances of Brian. Maybe she means inconclusive. I'm gonna look up unconcluded. Is that a word? Concluded, not having been concluded, meeting not finished, resolved, or decided. Okay, it can refer to a meeting, a case, or anything else that has not been brought to a final conclusion. So are we looking for a final conclusion for his financial circumstances? Basically, she's saying he's lying. That's what I get from it. Because he submitted it to the court. She's calling him a liar. But instead of saying it, she wants to use this $10 word. The judge sees you. The judge sees you calling the father of your child a liar, ma'am. And understand her determination in showing ceaseless good faith efforts to be permanently included and unremoved. You're already removed. You removed yourself, unfortunately. And you also removed George Torres, but he's removed in a way he can never see his children again. Of her child, regardless of location, time, or any other possible circumstances. Death can keep you from him, like what you did to George. Wherefore, the pro se respondent, Sarah K. Boone, respectfully requests from this honorable court grant the motion for appointment of the gal to preserve and protect her invaluable parental rights, not protect the rights of the son, not protect the best interest. It's all about you, right, Sarah? Appoint a qualified neutral. Okay, that's what they would do. Do you think she would appoint an unqualified, biased gal to justly order the gal to conduct an independent investigation? That would be the whole reason they would be hired or appointed. Consider the child's preferences when appropriate and submit a written report to the court for application. She's saying inappropriate in the event that her son says no, because she's repeating what she said earlier, right? You should consider it unless blah, blah, blah. And so if he says, I don't ever want to see her in person again, she has an out. Allocate or waive the cost. Allocate it to what? The JAC is not involved in this. As justice and equity require, they don't require it because you've lost your rights as a free citizen. Grant such other and further relief as the court deems just and proper. Respectfully submitted this 14th day of May. And then there's her certificate of service. I'm sorry, Miss Jackson. Okay, then we've got Peter and Nicole back into play because we have another typed written motion. So they're okay with furthering Sarah's efforts to take money out of the household of a single parent who's supporting her son. Motion to compel petitioner. So the gal was denied and the other one was denied, or not the financial, that one is in, but the gal that was denied. We looked at that at the top. This is the motion to compel petitioner for amended discovery responses and financial affidavit and enforce sanctions by the court. So she jumped the gun on this because he had already submitted the financial affidavit. So maybe that was a part that was granted in part, but the rest of it is denied. Petitioner filed his financial affidavit indicating he is and has been, quote, unemployed, end quote, for the past 3 years, 22, 23, and 24, and without income assistance or assets of any kind. That is not true. We went over that twice. He has money coming from a trust, which presumably is his family's trust, just enough to cover his monthly expenses. Petitioner has refused to answer duly served interrogations by the respondent. See filing May 6. We went over that. Ridiculous.
How much money did you sell the house for? Where did you do with the money?
Motion or demand, really. Respondent has evidence needed to be brought to the court's attention where she believes the petitioner is knowingly and willfully misleading the court. So hopefully you entered that in discovery that was due on the 20th of May, the day before your hearing. Hopefully the evidence you have has been entered properly, rightfully, correctly. Shared minor child has indirectly made statements regarding the petitioner having a real job and is not doing contract work anymore. How does one indirectly make that? I think she wanted to say, this is just my opinion. You have your own. You don't have to tell me what you think about mine. Peter and Nicole probably told her, Peter and or Nicole probably said, don't say the child is telling you things because that looks bad. So then they've softened it with indirectly. But how does that indirectly? Like, oh, he was sucking on a lollipop and said, Dad's at work. And that was the indirect. Because why are you guys talking about Brian at all on any conversation or in any letter? For what reason? How did that come up indirectly? The judge is going to pick up on all of this. Respondent has documentation showing petitioner receives regular family support. Where did you get the documentation from? And he already said, I don't think he said 3,000 to 17,000 or more per month in past years. Where did she get this documentation? If she got it from her son, she's in big, big trouble because she has been behind bars since February 25th of 2020. We are sitting on June 4th of 2025. Where did she get this documentation? Where he states 0 on his submitted financial affidavit and mandatory disclosure. These are wolf tickets, as my mom would say. She's selling wolf tickets because she doesn't have this. There's no way. Unless somehow her son is broken and she has him committing breaking federal laws by opening up the dad's mail and sending it. If this is true that he's getting 3,000 to 17,000 a month. But even if he is, he never stated that in his reason to amend, or in his reason, what's the wording? Reduce or eliminate, that he didn't have the money. He didn't state that. He stated because of the change in circumstances, i.e. she killed someone, I should not have to pay. So in my opinion, that's moot, but obviously I'm not the judge. Petitioner's financial disclosures appear incomplete or misleading in violation of the blah, 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 which requires full and honest disclosure. Yours require full and honest disclosure too. And I don't see anywhere on your financial statement where you're putting how, say, for example, Peter is sending you money monthly or Lana was sending you money for the last year. I only have November and I know they sent you money. Why does your financial statement say 0? And if I have it, Brian's attorney can pull it, the judge can pull it, although I don't think the judge goes digging for evidence, but I'm just saying it's out there, girl. It's public record, and you just lying. A party cannot unilaterally refuse. Equally, a party cannot unilaterally decide to change the due date, right? She changed it. She wanted the interrogatories within 14 days instead of 30 days as provided by statute. So pot, meet, kettle, y'all both black. Full financial disclosures is required under Rosen v. Rosen. I believe no, the other one I think is Rosenbaum. I can't remember. That might be the one where you can't hold them in contempt until it's resolved, but that's neither here nor there. Misrepresentation of financial status is a form of discovery abuse that may result in sanctions. You need proof for that. There's no point in just citing it here. You're selling wolf tickets. You're threatening him in the form of sending a letter to the judge that he will read. Argument. Petitioner's refusal to answer interrogatories and the apparent inconsistencies in his financial affidavit undermine the integrity of this proceeding and inhibit respondent's ability to properly prepare her case. Why? How does that inhibit you preparing your case? Can anybody think of a reason for her to turn in what she needs to turn in? It doesn't affect her financial affidavit, her own. It doesn't affect her time sharing. How does that impact her ability to prepare her case? Particularly with regard to equitable distribution. There's not any equitable distribution. Y'all already did that in the divorce. And potential support obligations. I don't think the judge is going to use his income. Like it was based on you being in jail and now in prison. I mean, they could, but that was not the argument that he made. I guess she couldn't make him pay $1,000 if he didn't have $1,000, hypothetically, but that's for the judge to sort out. And both he and his lawyer signed those documents. So you're calling the lawyer a liar. Not new to you. We know you like to call lawyers unethical and liars. But grounds. In petitioner's objection, so she's acknowledging that he did object to previously served interrogatories. Petitioner objects to the 14 days. Respondent respectfully reminds the court that the expedited timeline is due to the petitioners not submitting accordingly or truthfully. So that is just a flat out lie, because you sent in the original notice, you asked for 14 days. So there wasn't a chance for him not to submit accordingly before you demanded the 14 days. So that is just like word Jenga. Evidence suggests petitioner is either employed. What evidence? Did you enter it into discovery? Or regularly receiving substantial financial assistance from third parties. He's getting money from his trust fund. It did not seem substantial to me, particularly given that he's a single parent, running a single parent household for a growing boy. I heard like 14-year-olds, I'm getting nervous because I'll have 2 boys, can eat you out of house and home. 14-year-old boys, and the shoes, forget it. I'm saving up my YouTube money for my sons, both of them, their shoe fund. Listen, present monthly gross income 15 and 16, any other income or recurring nature. Petitioner has left this line item blank because he doesn't have income. He has no job and a trust fund payment monthly. In review of petitioner's credit card statement supplied for only April 26, 2024, we didn't see these, but they were submitted, to March 27th, 2025, 11 months, which if he only had it for 11 months, he only had it for 11 months. But wait, April to March is 12 months. April to April, wouldn't that be 13 months? Anyway, per month, the petitioner received between $3,000 and $17,000. Where is she getting that from? On a credit card statement, it doesn't show. They're not giving you money on a credit card. You're borrowing money and you have to pay it back. Like, is his credit limit $20,000 and he's spending? Maybe he's living off of his credit cards. What is she talking about? Combined total for all months in this time period was calculated at over 39,000 for this quote income end quote, and income tax return should have been filed, which petitioner is refusing to submit in one motion and saying none exist in another. You can't submit something that does not exist. But where the hell is she getting income from on a credit card statement? A credit card statement is just that, a statement of your credit with this card with this company, Citibank, Amex. Although Amex, you can have a charge card, which that would be more telling because you'd have to pay it in full every month. Expenses detailed on the financial affidavit provided by the petitioner do not include the petitioner's regular purchases of alcohol, cigarettes, video games, Uber Eats 5 out of 7 days a week. So she's getting that from the child. Football games, cruise packages, etc. Were you required to put cruise packages on there as a regular purchase? Do people regularly purchase cruise packages? More examples of inaccurate expenses include groceries, bill payments, cell phone, miscellaneous entertainment. Okay. Petitioner has left numerous entries blank or stated none exist, with which respondent can prove otherwise. So bring that evidence to court. Like, she's trying to pre-argue these. Bring it to court. Like, the judge can't rule on it without evidence. Do you know? Like, bring it to court. Put it up as part of your case in chief. Petitioner repeatedly lies about completing this task. Oh, wait, sorry. Let's go back. Also, respondent would like to bring to the court's attention that petitioner, come on, Peter and Nicole, I got a spell check. That petitioner refuses to complete visitation forms, which respondent has pleaded for him to submit since January 7th, 2025. Is he required by law? I don't think that a sharing agreement or that a share plan, a parenting plan has been agreed upon by either of you, right? And so the nasty way you talk to him, I wouldn't do it either till somebody told me I had to. For what? And who's bringing the visitor? Oh, she gets my blood up. Okay. Happy thoughts, butterflies, bumblebees. Boop, 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 boop. Petitioner repeatedly lies about completing this task, including to the minor child, who has been asking petitioner to finish and send numerous times when on the phone with respondent so that she can hear petitioner's response. So you set it up for him to do that, because why is it that he's only asking when you're on the phone? And if you keep asking the child to ask the father so you can hear, you are a bad parent. Respondent believes petitioner is willfully preventing the minor child from seeing his mother. Why? Foremost out of spite, but also because petitioner must enter employer's name, address, and phone number. Why? He's not coming to visit you. Why would he come visit you? But we do know, speaking of which, Peter got rejected. Now, his name was spelled wrong, but it seems like that would be quick enough to fix. But he was not accepted to visit Sarah. It said, I think, invalid or fraud detected, something not on the up and up there. But must enter employer's name. So she's kind of shooting herself in the foot, because if he doesn't have an employer and they require that, there's your answer. He can't fill it out because they're requiring something of him that he does not have. This entry will evidentially show that petitioner is currently holding employment and has been in the 5 months prior since respondent began requesting the visitation forms to be sent. Okay. Is it 5 months prior? She didn't get over there until December 30th. And this was written like May something. I think it's 4 months prior. You're in the 5th month when you're writing this. Relief requested. Wherefore, respondent respectfully requests that this honorable court compel petitioner to answer all previously served interrogatories is what it said. That spell check is failing these guys. Truthfully, within 14 days. So we know that is not within statute, so that is just silly for her to ask for it. Compel petitioner to file. Again, she's asking for someone to make new rules just for her. Compel petitioner to file an amended financial affidavit that reflects all sources of income. She has no proof that he's not. She's not submitting anything. There's no attachments. I suspect they probably argued this in front of the judge at the pretrial conference, and the judge denied it. I know for sure because we went over that at the top. Impose sanctions or issue a warning, blah, blah, blah. She's one to talk about having warnings issued for not filing things in a timely manner. Pot, meat, kettle, y'all's both black. Okay. So 5:30, this was filed. Motion to compel mandatory compliance and enforce sanctions to petitioner and his counsel for direct violations of the pretrial conference. So she's mad because they did not come and meet with her, or Josh did not come and meet with her as what the court ordered. But I think that is just like a form statement of like, you guys get together and meet. Obviously, the normal circumstance is not that one spouse is in prison in a different city. And Josh filed a notice like, yeah, we didn't want to go through all those logistics, so we're filing a loan. We don't oppose if she files a loan too. So Honorable Court entered a uniform order setting pretrial conference on April 28th. This order by the court requires the inclusion of both parties. Shall read this order, be familiar with its contents, and comply with its requirements. So she's already at fault, and she's telling on herself because she didn't comply with the requirements of that pretrial conference, of that order from the pretrial conference. Or no, oh my God, I'm saying it wrong. It is, the order was setting the pretrial conference. She's not in compliance with the uniform order, apart and aside from the setting a pretrial conference. She didn't get the financial stuff in. She just didn't comply. She still hasn't sent in her disclosures. Now, she asked for relief and it was granted on filling out the financial affidavit and it being handwritten, but that's like an interim solution the way that she wrote it. So she still owes like a proper financial disclosure. I mean, she's all kinds of wrong, but what is her little rule about the fingers pointing back? All of them are pointing back at you, Sarah, while you're pointing your gnarly finger at Brian. This direct and clearly stated order by the court requires the inclusion of both parties, petitioner and respondent, to cooperate, and shall read this order, be familiar with its contents, and comply with its requirements. So page 2, number 5, mediation. Parties must have completed mediation. So I think this is like Peter and Nicole taking things out of context and adding that. Mediation is off the table. It's been off the table. What are we on time? 40 minutes. Depending on how long it takes to get through this, I might pull up that one. But mediation is already off the table because way back when they asked her in, 2022, she did not want to do mediation. She has cancer. She can't make an appointment. She has questions. What if it has to be changed? So it was dead in the water. Nobody's going to go back and forth with you. Nobody's giving you legal advice. Give us dates or let us know if these dates work. Period. Full stop. But she's got to have control. Oh, I can't do that. I need this, 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 and this before I do that. Well, half of it was legal advice, which the attorney can't give her. So she refused mediation. Meeting of attorneys and unrepresented parties no later than 20 days before. Attendance at this meeting is mandatory. Petitioner's attorney shall arrange a mutually agreeable time, date, and place at the meeting. So that's the thing. It can't be mutually agreeable. He doesn't want to go into the prison. There is no mutually agreeable place because you can't come out. So she goes on about what's in there. Page 3, section 9, joint pretrial statement. He made his own statement. The memorandum shall contain the following for each area below: original or supplemental proceedings, the children, alimony. He submitted all of that. It's her turn to submit it. I don't remember what this good faith estimate is in the financial affidavits, but when she wrote this, she hadn't submitted her financial affidavit. Brian and his team had not seen her financial affidavit while she's pointing the finger at them about not having this meeting. They noticed her. They weren't having this meeting. They weren't coming in to see her. And then how does that even work? Because he's not her lawyer. How does he get into the prison? He submits to be on her visitors list. You know what I mean? Like, they didn't want to do it. refusal to cooperate, if a party refuses to cooperate with the filing of a joint pretrial statement or a joint equitable distribution spreadsheet, each party must file its own, which is what they did at least 5 days prior to the pretrial conference. She did not do that. It's like the people typing this out, Peter, Nicole, you didn't read it. She didn't type hers out. I know Lana sent you this court date sheet because she asked me if it was okay if she shared with you, but you didn't read it. So each party must file its own pretrial statement and or spreadsheet at least 5 days prior to the pretrial conference. Sarah did not do, and bring a copy of the pretrial statement to the pretrial conference accompanied by the communications between the parties and or their attorneys. There's no communication, so there's nothing to bring, at which time the court may direct a party to be responsible for the creation of a joint pretrial statement, issue sanctions and or attorney's fees. So the court directed you, Madam Boone, to get your ish together and submit it. Notification of settlement. Parties will notify the judge. There's not going to be a settlement. Unexcused failure of counsel or unrepresented party. A2, attend the meeting. Oh, this typos. Of attorneys required herein, pretrial conference or trial, or to comply with requirements. They had all the time to look this up, but not the time to just do a Google search for the financial form. The judge is going to see all of this and call it like it is. May 8th, petitioner ignored and violated the court's order by unilaterally filing a written response. No, by your own words, that wasn't ignored, because up here you say that they are to file their own. Where was that? You're contradicting yourself within your own statement. Sorry, I'm scrolling backwards. It was here somewhere. Wait, I'm getting myself all worked up. It even says to the point that they differing views should be set forth in the statement. If a party refuses to cooperate, each party must file its own pretrial statement. So you're contradicting yourself. You should have filed your own by your own words. So they didn't ignore and violate. Petitioner and his counsel have refused to cooperate with the court. No, they haven't. They submitted it timely. It's order. Follow the order. And the respondent, did they refuse to cooperate, or did they just say they didn't want to go through the trouble? In any manner to include her to comply and complete this just and mandatory meeting of attorneys as directed. The meeting is only for the purpose of getting the document. So because they created their own document, the meeting was moot. Like, you knew they were not going to meet with you because they noticed you. So at that point, it was in your best interest to complete the document, which as of the writing of this, you still haven't. So instead of writing 6 pages of, they didn't do what they were told, why didn't you put on your big girl panties and write out your own pretrial? What is it that you want? Because then you'll be complaining you didn't get what you want when you didn't say what you wanted. You're always setting yourself up to be the victim, like now and futuristically. The respondent made her own attempt to schedule this meeting of attorneys. No attorneys, ma'am, just you and the petitioner's attorney. By having her outside resource contact the petitioner's counsel via email on May 12th. So that is going to be Peter, because we saw multiple things filed with the court from Peter with his email. And someone asked me, why are you saying his name? Why can't I say his name? I redacted his email, which is required by YouTube standards and practices. Nowhere on there does it say I have to redact the name of someone who's filing documents publicly. Peter Gunthal, creative, or Delapine Creatives, is helping Sarah defraud her husband, her ex-husband and son of money. As nothing, using the court to do it. Vexatious litigants, the lot of them. As nothing has been received, as with other documents mailed by the petitioner, top stress and heavily emphasize her eagerness. Top stress. So not stress as in she's stressed, but like she's underscoring, like she's stressing, like underscore, bold, italicized, her eagerness to participate in the meeting. No response has been received to date. And you're not going to get a response because on what date did they send you that note saying they weren't going to do it? In addition to the petitioner ignoring the respondent, violating her due process, nobody's violated your due process. You can still complete the sheet without them. Tell the court what you want, which is what she ordered when you got to pretrial conference. Demonstrating unlawful procedural fairness. Brian's not responsible for the procedural fairness. The court is, and she denied this. So that didn't work out for you. She also received this pretrial conference order on May 15th. The envelope is stamped May 7th, my birthday, sent from the court 14 business days after generated on April 28th. So what? You knew it was due on April 28th, irrespective of what Brian was doing. If you didn't have a meeting on the 27th, you knew there was no way you guys were going to get it together and have a joint statement on the 28th. So what was stopping you from taking responsibility and accountability for yourself and completing the document? We'll wait. Okay. Legal argument, pretrial orders are mandatory, blah, blah, blah. The judge knows all of this. Incarcerated parties retain the right to meaningful access to the courts and to participate. You've had full access to the courts. Nothing has been restricted to the courts. It's not Brian's responsibility to get you access to the courts. And as you stated in your own document, the judge said if you don't do it together, you can do it singularly. What was stopping you? Florida courts have consistently held that an incarcerated litigant has a right of access to the courts that must be protected. You have full access to the courts, particularly when fundamental parental rights or matters of family law are at stake. She gives no example of how her access to the courts is not being protected. None. What? How? Tell us in what way you haven't been able to exercise that right. Petitioner's decision to refuse to meet, confer, and communicate heavily impedes her guaranteed. No, it doesn't, because there's an out for that. Write your own. 20 days notice must be given before a pretrial conference on failure of a party to attend a conference. Well, everybody attended the pretrial conference. The pretrial conference is in front of the judge. So what are you going on about? On a failure of a party to attend a conference, the court may dismiss the action, strike the pleading, limit proof, or witnesses are taken. Do you want them to really dismiss the action? Because it seems like you're kind of begging for money. They dismiss it, you get nothing. Petitioner cannot unilaterally decide to disobey the court's order. You did. You decided. Can the respondent unilaterally decide? Because you didn't turn in the stuff. You were like this document of what you wanted. Pot, meet kettle. Y'all's both black. Therefore, all aforementioned items are still to be concluded, which may have been already. Would they have been compiled and cooperated as instructed? This is Sarah's writing. I know we looked at that other one and you guys were like, she didn't write this one, but this with all the extra words is definitely, she had a hand in it. Issue another order compelling petitioner to communicate. Nope. Require petitioner to comply. He already did. They said he could do it all by himself. Individually, he submitted the document. Enforce appropriate sanctions. There are no sanctions. He followed the order. Warn petitioner and his counsel. Continued failure. You haven't established a first failure, so continued failure. Objection. Facts not in evidence. Grant any other relief the court deems just and proper. Tell this nut to get it all the way together. So yeah. back to this. They accepted her handwritten financial affidavit. We went over that. Guardian ad litem denied. Respondent's motion to compel mandatory compliance and enforcement granted in part, which he already did individually. And then the court admonished counsel for failure to comply. So that's Sarah that they admonished, we know now. And they gave her 30 days to write out position on a pretrial statement. To compel for amended discovery, that was denied. Her 14-day nonsense. And all of her, I have proof he's lying. My son said. Both parties are to submit their parenting plan within 30 days. So, trial's August 25th. I'm definitely going. We're going to send her out with the bang because I can't wait to wash my hands of Sarah. And, what better way to do it with a smile? At the end of her hearing, where all her stuff is denied and she loses the rights that she thinks that she has. Okay, let me please hold and I will look for the mediation bit. Okay, I was able to find it. This is, can you guys see that? Yeah, 4/8/28. Order after case management conference on March 26th for Brian C. Boone and Sarah K. Boone. Those are the pending motions listed, but here, number 4, respondent made an ore tennis motion for mediation to which petitioner objected and the court denied. So where and why it's coming up in this other document about they failed to participate in mediation, I don't know if it's an intentional lie, but it sure is silly because it was in the last document. And so to say that it just takes the wind out of her sails, you know what I mean? Because you can't be trusted. You're not a reliable narrator. The court has all the records. The court remembers that the last time you guys were together before this pretrial conference, you made an oral argument for mediation and it was denied. So then the next time you write something to say that they are violating a court order by not mediating, you just lose credibility. So then when you come up with things like my son told me, it just makes you look bad. But I guess you don't care. You're a murderer. You can't look any worse, right? Let me know what you guys think down in the comments below. I'll talk to you later. Toodles!